Hi, and welcome to this talk on legal aspects of AI. My name is Kjetil Sætre. I'm an associate at the law firm Thorkildsen. Today, I'll try to give an introduction to and overview of some of the legal aspects you, as a developer, architect, or manager within IT, will be affected by and have to take into consideration in your line of work. Hopefully, this will help you in the future to better cooperate with your employer's legal counsel, making both your and their jobs easier. A little bit about myself. As I said, I work at the law firm Thorkildsen. We're based here in Oslo. Most of my work relates to IT contracts, data protection, and intellectual property. Thorkildsen represents a wide range of clients, such as, for example, Google, Accenture, Bouvet, Questback, and Norwegian Roads as administration. I have also previously worked at the Norwegian Research Center for Computers at Law at the University of Oslo and at NRK, which means Norsk Rikskringkasting. In this talk, I cannot get into every legal aspect of AI or the risks involved. Therefore, I will focus on privacy and data protection, GDPR, intellectual property, liability, and contract law. But first, what is AI? Before getting started with the legal aspects, we need to establish what we're talking about. As you know, lawyers love a good definition. A commonly used definition for AI is the ability of a digital computer or computer-controlled robot to perform tasks commonly associated with intelligent beings. The problem with this definition is, to date, there are no such digital computers or robots in existence. Therefore, when we talk about AI and its legal aspects today, we normally refer to some sort of machine learning or big data analytics. On this background, I'll give you the first legal lesson of this talk. The involvement of machine learning or big data analytics does not fundamentally challenge general principles of law. It just makes them harder to apply. This means that when today's AI goes wrong, the courts, in principle, have all the tools they need to reach a fair decision. It's just harder to understand the facts of the case. From your perspective, the takeaway lesson should be this. The more complex your machine learning / big data project is, the closer you get to true AI, the more important it is to closely consider how to address key legal risks associated with your project. Okay, so now you have a general idea of the point of this presentation. Let's get started with the specifics and some examples. Starting with the GDPR. I'm guessing you are all familiar with this topic, probably more than your liking. As you know, the GDPR relates to all processing of personal data within the EEA area or processing of data subjects within the EEA when carried out in relation to the offering of goods and services or monitoring of behavior of such data subjects. My point is this. If AI is applied to personal data, the GDPR comes into play. And the more complex the AI in question is, the harder it is to comply with the GDPR's key requirements. This means that it's harder to comply with, for example, the need for a legal basis, especially when relying on the balancing of interests alternative, cf. the GDPR Article 6(1)(f). Furthermore, it's harder to comply with the requirements on risk assessment or data protection impact assessment. Further, the information requirement. How do you give adequate information to data subjects on how their data is processed when using AI? And last but not least, landing a well-balanced data processing agreement between the controller and processor can be challenging. The key point when talking about the GDPR and AI is, when working with AI, start your GDPR homework early and document how you're going to comply with its many requirements. Due to the heavy regulatory risks associated with data privacy breaches, there is simply no way around this if you want your project to see the light of day. From a practical point of view, though, it is worth noting that the Norwegian Data Protection Authority has published a report on artificial intelligence and its data protection implication. The report is a good place to start the quest for GDPR compliance in relation to AI. It touches on topics such as AI and the fundamental privacy principles, risk assessments, and AI in connection with data protection by design and by default. The second topic I'd like to address is intellectual property. If you invest heavily in an AI project, you want to make sure that the results of your work is protected. How you go about achieving such protection will vary depending on the AI tech in question and whether you are on developer or customer side of the project. In any case, there are some legal aspects you should know and consider anyhow. Firstly, different variations of AI can be subject to varying levels of protection. For example, if your AI is implemented in a software, the software itself can have protection under the Copyright Act, Section 2.2L. However, the important part of a software implementing AI is the algorithms involved. And this brings me to that there is a general perception that algorithms, which is a central component of AI, as I said, are merely IDs that don't meet the basic criteria for copyright protection, namely the threshold of originality. And even though this perception is being challenged in legal theory, it still means that there's a risk that your algorithms may be copied and used without your consent. Therefore, if the project you're involved in is of such a character that the algorithms themselves are the most important part of your AI technology, you should take steps to keep them secret. For example, through encryption or through confidentiality obligations in your contracts with your customers. Furthermore, how about patenting? A patent, as you might know, can be granted for a technical solution to a practical problem. That's the most common definition. The criteria is that the invention must be new and not merely a logical next step from a previously known technique. This means that the AI must be implemented into a technical solution in order to be patentable. Furthermore, the patenting process can be cumbersome and carries no guarantee that the patent actually will be granted. This means that the decision of whether or not to embark on the patenting journey, as you might say, must be carefully considered. When implementing anything complex, such as AI, there's always a chance that something goes wrong and that some kind of damage, harm, or loss is inflicted on one of the parties involved, or even a third party. The question then arises, who's liable? There are several bases to answer the question, depending on who the damage or loss is inflicted on and the other facts of the case. One practical alternative is the so-called product liability. This can come into play when AI is implemented into a physical product. If the product causes harm, the producer can become liable. The main criteria is that the harm is due to inadequate security compared to what the user or the public could reasonably expect. As you can imagine, what one can reasonably expect is not easy to determine in any given case. A similar problem arises with the most common form of liability, namely negligence, eller uaktsomhet på norsk. Under the rule of negligence, a person or entity can become liable for damages arising when their actions or lack of actions are negligent compared to what objectively would be considered good, proper conduct. In practice, how can you prove that the developer of an AI technology or product has acted with negligence? The burden of proof lies upon the party which has suffered the damages. We can imagine that there will be some unreasonable outcomes when such cases are first brought to trial before the courts, simply because the plaintiff won't be able to prove that the developer or owner of an AI technology has done something wrong. This again might force lawmakers to enact new legislation, perhaps with strict liability as the result. Strict liability is what we in Norway refer to as objektivt ansvar. Even though it will be hard for a third party to prove negligence or product liability, the risk of lawsuits is something that developers and buyers of AI tech should take into consideration. This brings us into the contractual aspects of AI. Now, let's assume we're in a situation where the parties involved are a IT supplier company, developer on one side, and an IT buying company, the customer, on the other side, in a project involving the use of AI. What are the key aspects for these parties to consider in the contract? Now, first and foremost, as in any other case, the contract is the instrument where the parties put down in writing their expectations towards each other. What must each party do in order for the project to be successful and both parties to be happy? In a traditional IT contract, the customer will establish criteria that the supplier then answers in their solution specification. This form of contract creates a static contract with little room for the product or the AI to evolve. And given the evolving nature of the technology in question, which is which is what we want. That's the entire point of the technology. There are some issues that the parties must solve in a contract around AI compared to a more traditional IT contract with established criteria and a solution specification. From the customer's perspective, how do you put into writing what you want to achieve in a way that is both specific enough to actually hold the supplier responsible for delivering a specific result, without losing the potential associated with an ever-evolving product? And all this while still keeping the cost down. And from the supplier's perspective, how do you describe your deliverables, in a way which enables you to keep developing the product without overselling and without taking responsibilities for unpredictable results? As you see, there are difficult questions to ask and to manage on both the customer and the supplier side of things. Now, this quid pro quo part of the contract is difficult enough. It is difficult enough to put into writing what the customer wants to achieve with the AI, and it's difficult to put into contract what the supplier can actually deliver and stand up to. Now, in addition to the quid pro quo, the parties will have to consider and strike the proper balance with regards to all the subjects we've discussed earlier, including who's responsible for what with regards to data protection. For instance, if the customer, let's say the customer is the data controller, the data controller as a starting point is responsible for informing the data subjects of how their data is processed. But when the data is processed through algorithms and AI technology developed by the supplier, the data processor, how do you decide who's going to establish the correct information for the data subjects, and who's liable if the information turns out to be false? That's data protection, just one example. Next question: does the supplier keep rights to the IP, the rights to use the AI technology further? Probably. They want so. If so, what licenses are granted to the customer, and how are they put into writing? How do you give the customer wide enough licenses to take into account the evolving nature of the product or technology? And importantly, what kind of liabilities can arise, both between the parties and toward third parties? What can happen, and who's going to cover the costs when something goes wrong? As I stated initially, we, in principle at least, have all the legal instruments needed to deal with today's AI, which is AI that is based on machine learning and algorithms, not true AI. Still, the more advanced AI technology gets, the harder the traditional legal doctrines are to apply. And this raises questions on whether any legal developments are needed. And there are developments going on. We have no concrete suggestions on the table, but this is a hot topic in the EU, in Norway, and in California. As a finishing remark, I would like to refer you to the 7 key requirements for so-called trustworthy AI as identified by the EU Commission. And even though these requirements are not materialized into binding legal rules yet, they may very well be in the future. Besides, you can tell if you work with, for example, human rights or data protection, privacy, that these are principles that are integrated into already existing laws. Therefore, they may be worth reading up on already now and consider if you are associated with a project involving something you would describe as AI. Now, the first principle is human agency and oversight. There needs to be human involvement in any use of AI technology. At least that's the principle here. The AI needs to be subject to safeguards with regards to technical robustness and safety. Of course, privacy and data governance needs to be taken into account. Transparency is a major issue to safeguard and take into consideration. A very hot topic is how do you stop AI from producing discriminatory, unfair results with threats to diversity as a result. This is also one of the key principles. You also have to take into consideration whether the AI you are developing affects societal and environmental well-being, and the principle of accountability. Someone has to be accountable for the AI technology and the results from applying it to any given situation. That's what I wanted to share with you. Hopefully, what we've been through today will help you have some keywords in the back of your head the next time you're forced to cooperate with your legal counsel in association with the AI project. And should you have any questions or would like me to elaborate on anything, feel free to shoot me an email, give me a call, or DM me on my Twitter, for example, if you have any questions. Thank you.